It is well known that the Article 12 to 35 of the Indian Constitution deals with the fundamental right. There are 6 main fundamental rights, and Constitution tells us that these rights are inviolable. The elementary question in controversy when it comes to amendability was, first, are these fundamental rights amendable? And secondly, if these fundamental rights are amendable, what is the extent, scope and authority of the Parliament to amend the Constitution? Supreme Court has time and again tried to answer this question through various judgments. The first case in which the amendability of fundamental rights arose was the case of Shankari Prasad Singh versus Union of India. In this case, the validity of First Amendment was challenged on the ground that it purported to abridge the fundamental right under Part 3 of the Constitution. The contention raised was, as per the provision of Article 13, if no law can infringe the fundamental right, then how can the First Amendment violate the fundamental right? Hence, the validity of First Amendment was so challenged. The court held that amendment is not a law within the meaning of Article 13, Clause 2, and it went on to held that the amendment is valid even if it abridges the fundamental right. Following Shankari Prasad was the case of Sajjan Singh versus State of Rajasthan. In this case, court upheld the judgment of Shankari Prasad and reiterated that the word law in Article 13 does not include a law passed by the Parliament by virtue of its constituent power to amend the Constitution. Immediately after the case of Sajjan Singh, the question of amendability and the validity of the previous case of Shankari Prasad and Sajjan Singh was challenged in the case of Golaknath versus State of Punjab. In this case, it was urged that the previous case of Shankari Prasad and Sajjan Singh was wrongly decided. And in this case, the Supreme Court reversed its earlier decision of Shankari Prasad and Sajjan Singh and held that Parliament under Article 368 had no power to amend Part 3 of the Indian Constitution. All in all, it took a stand that fundamental right cannot be amended. Golaknath case created a lot of issues in the judiciary as well as the Parliament, due to which the Parliament enacted the 24th Amendment Act, which amended Article 13 and Article 368. After this, a lot of questions were raised, due to which 13-judge constitutional bench was formulated in the case of Kesavananda Bharati versus State of Kerala. Kesavananda Bharati challenged the validity of the Kerala Land Reform Act 1963 and the validity of 24th, 25th and 29th Amendment to the Constitution. The court, in the case of Kesavananda Bharati, held by 7:6 ratio that no part of the Constitution, including the fundamental rights, was beyond the amending power of the Parliament, thus overruling its previous judgment of the case Golaknath versus State of Punjab. It went on to held that the basic structure of the Constitution could not be abrogated even by the constitutional amendment. Thus, for all, it concluded 24th, 25th and 29th Amendment Acts are valid. Golaknath case was wrongly decided. There are no inherent or implied limitation on the power of amendment under Article 368, and the power of amendment is plenary and can be used to amend all the articles of the Constitution, including the fundamental rights. And lastly, the power to amend does not include the power to alter the basic structure of the Constitution so as to change its identity. So, the final words on the issue of amendability can be related to basic structure defined in Kesavananda Bharati's case. To name a few, Minerva Mills, SP Sampath Kumar, L. Chandra Kumar case are well based on the principle of basic structure, and this situation is unlikely to change in the near future. It is clear that all the laws and the constitutional amendments are subject to judicial reviews, and the law that transgress the basic structures are likely to be struck down by the Supreme Court.